heavy thing, based on the Ray Vindicatio. Will you all do that for me? I'll resume. You must stay online. I'm just going to mute myself. And then in 2 minutes or 3 minutes, I'll ask some of you to just read me what they've drafted, okay? Has anyone had an opportunity to look at it? So let's ask Janel van der Westhuizen. Simone Adler. Any volunteers? No one. Ben Louis?
I'll volunteer if Ben Louis doesn't want to.
Claudia, go. Thank you for answering. Yes. So how would your first clause be?
Well, first you would introduce the plaintiff and the defendant, if I have it correctly. So
excellent, yeah.
I'd cite myself. The plaintiff is me. I'm an adult female candidate attorney, and I would state where I live and where I practice. And then the defendant. And then I would explain the facta probanda, which is the essential elements of this claim, which would be that I am the owner of a cell phone, for example, and on so-and-so date, I lent the cell phone to the defendant who was supposed to give it back, who has not given it back, and then I will basically explain that the cause of action is that he's holding my property and I want it back. And yeah, then basically I just say that this arose in the jurisdiction of the court, and I will pray for judgment, I think.
It's excellent answer. You're quite right. Let me just certain things, and it's without any help of AMLers that I said is the Bible. Let me just show you. Can everyone see me, or is it still the screen share? Hang on. All right, here we go. Can everyone see me?
Yes.
Yep.
So this book is the book to have. So if you go under evictions, vindication, you'll see it tells you cause of action. An owner is entitled to reclaim possession of his or her property with the Ray Vindicatio. The action is an action in rem. It may be advisable for a plaintiff to claim alternative relief on the assumption that the defendant may have disposed of the plaintiff's property before the institution of the action. Then it tells you what is the essentials that you need to plead. A plaintiff must allege and prove ownership of the thing that you said, and that the defendant was in possession of the property when the action was instituted. And then where they said that you must make provision for if he's disposed of it. So you will say, and it then gives you a precedent. Here we go, if you can see it. Plaintiff is the owner of the property, defendant is in possession thereof. In the alternative to 2, and if it is found that he is no longer in possession, the plaintiff alleges he disposed of it with the knowledge of the plaintiff's ownership and the value of the property. The plaintiff claims for delivery of the property, alternatively payment of the amount. So you were quite successful in your answer. Well done. So this is the next one I want you to do. A claim based on rental. So if you claim someone owes you rental, let me just share the screen, sorry. What would you've explained your plaintiff, you've explained your defendant. What would paragraph 3 do? What would the facta probanda be? Together with a probantia, because you can't just distinguish the two, it entwines with each other. Estienne?
Facta probantia would be that the probanda is that he didn't pay the rental.
No, but you're now drafting a particulars of claim, so go in sequence. You are Estienne, Harold Mile. Okay, yes. And then paragraph 3, what is the first thing you will first mention?
That there was a lease agreement entered into between the plaintiff and the defendant on a certain date.
Perfect. Good answer.
Okay.
And then the third one would be the defendant breached the agreement in that it failed to pay the rental for the months of so and so and so and so.
Yes.
As a result, correct, the plaintiff claims the amount is still out, notwithstanding demand, it's still due, owing and payable, blah, blah, blah. So excellent. So on the same rental facts, if you have a surety, what is your main document for the surety? A surety, in terms of the General Law Amendment Act, must always be in writing. Hopefully all of you know that. You cannot bind yourself as a surety orally. That's not permissible in terms of the General Law Amendment Act. There's certain formalities that a deed of surety needs to comply with. So on the same set of facts of the rental agreement, your cause of action on a surety's indebtedness will be the deed of surety. But as you all know, a surety is dependent on a principal debt. Right? So it will always be based on a principal indebtedness, which in the realm of a rental agreement will be the rental agreement and the principal debtor's indebtedness. So you'll first plead the rental agreement. You'll say, on such a date and at such and such a place, the plaintiff and Piet Pompies, herein after referred to as the principal debtor, entered into an agreement of lease in terms of which the principal debtor leased the premises situated at so-and-so. The terms of the agreement was X. The principal debtor breached the agreement and is indebted to the plaintiff in the sum of X amount of money. On such and such a date, the defendant bound himself as surety and co-principal debtor for the due and punctual fulfillment of the obligations of the principal debtor. The surety has failed to effect payment of the principal debtor's indebtedness, and as a result of the principal indebtedness and the deed of surety, is liable to the plaintiff. So that's just in a very short nutshell. There's certain other things that you have to put in, like the exceptios that a surety as a matter of course has available to it. But that's just a basic skeleton of the particulars of claim. So if you want to draft the particulars of claim based on goods sold and delivered, you will say the defendant is indebted to the plaintiff in the sum of sums for goods sold and delivered at the defendant's special instance and request in the amount of so-and-so, and then you're going to attach your invoices. And in all of these examples, you will attach the agreements on which you rely. All right? So you have to plead the material terms of your agreements. You have to plead if someone has consented to the magistrate's court jurisdiction, especially if your claim amount exceeds the jurisdictional threshold of the court. So in terms of the NCA, the particulars of claim is far more lengthy. And you can look at, I would assume those that don't even have the notes won't have these questions. There's a little handout pack that answers the questions on the questions after each chapter. And in that answer, specifically page 1, let me just double check. There was one where they comprehensively did a particular claim on the NCA. But there you also have to plead your agreement, your credit agreement. You have to plead compliance with the Act, with Section 129, with all of those provisions. So in your notes, it's quite comprehensive. I'm not going to deal with it in full now. So just have regard to the particular based on the NCA. So you quote your parties, whether or not the NCA is applicable, any other provisions, etc. So you've also got to make provision for, in your particular claim, for the claim for interest. Okay? Because remember, you want interest to run. You do it in your letter of demand, then you have to do it similarly in your particulars of claim. So if there's an agreement between the parties, you have to say it's a material term. And usually you will when you rely on the agreement and you set out the probancha on the agreement. If there's any legislation applicable, like the prescribed rate of interest, which we know is now 8.5. Okay. How do we serve a summons? Rule 9 deals with service. Who serves the summons? It's the sheriff. And on who can the document be served? Who can venture what would be valid service? Ben Louis, jy het nou 'n antwoord geskep daar. So, talk to me. On whom can a summons be served?
A summons must be served on the defendant, as far as I understand it, or if he has appointed a legal practitioner already, a legal representative already.
Must it be personal service?
As far as I understand, the summons must be personal.
Okay, now there is, in terms of Rule 9.3, there is, it's permissible to serve on, obviously on the defendant personally, or his duly authorized agent, as you quite rightly pointed out, or anyone older than 16 at his place of residence or at his place of employment. Where can the summons be?
It can be affixed. It can be affixed to the door of the defendant if it states that it is his domicilium address.
No. So, in terms of the magistrate's court rules, you can serve at the place of residence, where on someone older than 16, at the place of employment, at the domicilium sitandi by leaving a copy, as you point out. But Rule 9.3 says if the court is open to doubt that the process came to the actual knowledge of the defendant, the court may treat the service as invalid. So you cannot, it is not effective service to serve a document on a domicilium sitandi address where that notionally can be under a rock. The court will not deem that service. It's not effective service. Your court will also not have jurisdiction. Remember what I said? A court doesn't have jurisdiction on a domicilium address. It is only where the defendant resides. Okay, so that's a very big difference. Effective service versus has the court got jurisdiction? You can serve on a domicilium, but you do it at a very big risk that the court will not accept that it was valid service, especially if the return of service says it's a vacant land and it was put under a rock, or it was attached to the door, no other service was possible, and it seemed as if the premises were empty. So how do you avoid situations like that? Instruct a tracing agent, attach the tracing agent's report so that you can be in a position to convince the court that the debtor or the defendant in fact resides there. Okay.
I think also, can I add?
Yes.
Also, there needs to be a return of service with proof that the defendant has received the summons.
Yes. However, legitimate service is also, for example, if a defendant is a company, by serving it at its registered office address. Now, 3/4 of the companies in South Africa's registered office addresses are their accountants. So I go and the sheriff serves on the registered address and he affixes a copy of it on the main door of the office. Okay? The court can, the rules have recently changed. It was always that where it's served on the registered office address, that is effective service, because it is the prerogative of the defendant to maintain an accurate registered office address. Okay? So if I go look at the rules, I've still got the old rule book. It says all process in the case of a corporation or a company by delivering a copy to a responsible employee at its registered office address, or if there is no such employee, by affixing a copy to the main door. But it says if service is affected in that way, the court may, and this now has changed to include E. If the court has reason to doubt whether the process served has come to the actual knowledge of the person, it may treat such service as invalid. So one must be very careful. Ideally, your first prize is personal service. Secondly, equip yourself with a relevant proof that the address where it's not only affixed is indeed the address of the defendant. So now we've dealt with the service of a summons, and now the defendant has one of two options. He can avoid it and ignore it, which we'll deal with later, or he can defend it. Okay? How many days? We've gone through it, and the gentleman that listed what must be in a summons quite rightly pointed out, how many days do you have to file a notice of intention to defend?
10.
Correct. If it is against the state, how many days do you have against the state? Or how many days does the state have?
60.
No! They wish, no, they've got 20. Okay. If the address is more than 100 kilometers away, the service address, let's assume, okay, it's a bit of a difficult question. It's more to do with the High Court. But on that point, in the High Court, if your address for service is 100 kilometers more away from the court, for example, the Western Cape High Court has jurisdiction, but the person resides in George, you will have 21 days to file. So always remember that little scenario. So who can tell me what the 16th of December to the 15th of January is? Holiday.
They may not be included in the calculation
Yes,
of the time.
none.
Yes, but well done. It's des non. And what happens in des non? The answer is plainly nothing. Am I right? Everyone goes on holiday, especially the clerk of the court. But des non applies to the filing of a notice of intention to defend and a notice of bar and any pleading. Okay? If you file a defective notice of intention to defend, you have to file if you receive a defective notice. Now remember, these days in your summons you will elect an electronic address, especially in these times. I think all of the practices around South Africa has now resorted to electronic service of documents. And if you haven't, they're just, it's very yesterday. So in your summons you will, as a matter of course, say the plaintiff elects electronic service and invites the defendant to do so as well. If a lot of times a defendant acts on his own behalf, he represents himself, and they don't know how a notice of intention to defend must look like. So it's defective. They don't even give you an address on which you can serve documents. They don't give you an email address. You have to file a Rule 12.2 notice. Tell him how his notice is defective and grant him 5 days to rectify that defect. Okay. So now you've got a notice of intention to defend. Who can tell me what has recently happened with regards to the procedure called summary judgment?
Wasn't it that it used to be that you could apply for a summary judgment if there was no notice of intention to defend, but now you have to comply with the plea first?
Correct. So until recently, you could apply after notice of intention to defend for summary judgment. The rule has now changed. You cannot apply for summary judgment anymore after a notice of intention to defend. You have to wait until the defendant has filed a plea, and then you can apply for summary judgment. So the principles behind summary judgment will remain the same. It's just when you bring the summary judgment. And also, a plea. You will now be in possession of a plea that could point out, there's someone that's not on mute. Let's see. Okay, the noise gone away. So you can now, with the rules change, now you are in possession with a plea, and now you can get an idea of what the defense is, whilst previous to the rule change, you didn't know. So as a matter of course, on a liquidated claim, you always brought an application for summary judgment. So the rules and the law apply the same. It's just when you bring it that is different. So Rule 14 deals with summary judgments. The purpose of a summary judgment is to prevent a plaintiff's claim from being delayed. It's only when it's based on certain causes of action and when the delay will amount to an abuse of process. So you bring, this is now totally irrelevant. You don't bring it within 15 days anymore. You do bring it within, let's just see the new rule change, within 15 days after the date of service of the plea. So you're within the same periods, it's just after filing of the plea, not after filing of the notice of intention to defend. So when can you bring a summary judgment application? You bring it when there's a liquid document, like an acknowledgement of debt, like an agreement, when it's for a liquid amount of money, when you ask for a delivery of movable property, or ejectment from premises. Okay. In the SCA decision of Jub Investments, it's quite an interesting case. The judge on appeal, NAFSA, I don't know if anyone has ever had the privilege of seeing him in action. He's an excellent judge, doesn't take any nonsense. And in that case, he said, perhaps the time has come to discard these labels and to concentrate on the proper application of the rule. And why did he say that? He says, summary judgment is one of the last things that especially a magistrate's court grants. Because why? They make the defendant makes the allegation that the doors of justice are closed in my face. And you can imagine that you're defending a matter and just on affidavit, a court can decide whether or not you've got a defense or not. So it's quite a, the labels were, it's an extraordinary remedy. It's really a remedy that must scarcely be granted, etc. And the court said there, the summary judgment procedure was not intended to shut a defendant out from defending, unless it was very clear that he had no case. It is intended to prevent sham defenses from defeating the rights of parties by delay, and at the same time causing great loss to plaintiffs who were endeavoring to enforce their rights. The rationale for summary judgment is impeccable. The procedure is not intended to deprive a defendant with a triable issue or a sustainable defense from his day in court. After almost a century of successful application, summary judgment can hardly continue to be described as extraordinary. Our courts, both of first instance and at appellate level, have during that time rightly been trusted to ensure that a defendant with a triable issue is not shut out. So there's this, and it's also usually the defendants that argue this at the hearing of a summary judgment, that it's extraordinary, it shuts the doors of justice in the face of defendants. Now, that could be the case in certain instances. I'm not denying that. But summary judgment is designed to flesh out those that actually have no defense. And that links to the change of summary judgment in where you can apply for it. And it also is far more beneficial and far more effective to have a summary judgment after the filing of a plea than before. Because a plaintiff can now elect, after receiving the defendant's plea, to apply for summary judgment. And then the defendant has the right, which you will now see, to file an opposing affidavit. So the odds of a summary judgment being granted in where it's now will be very rare. And it's all going to be dependent on how your plea marries with your affidavit opposing summary judgment. So the times of just filing a plea, denying everything, it's going to bite you if you file a simple plea denying everything and then file an opposing summary judgment. So it'll be very I think when an application for summary judgment is brought, the defendant is going to be in a very precarious position to oppose it, because, and on the converse, a plaintiff will only apply for summary judgment when he knows this and he's got a fair apprehension that there is no defense here. So the plaintiff in an application for summary judgment is limited to his affidavit. He cannot sneak in anything. And what can he say in his affidavit? He can only say that he verifies the cause of action, that there's no bona fide defense to the action, and that the notice of intention to defend was purely filed for the purposes of delay. Now that will not change, because if we look at the rule, it says in Rule 14.2b, the plaintiff shall, in the affidavit, verify the cause of action, the amount claimed, if any, identify any point of law relied upon, state the facts upon which the plaintiff's claim is based, and explain briefly why the defense as pleaded does not raise any issue for trial. So let me give you a good example of when what is pleaded will not be a triable defense. So I have a contract, or I've got a client that's terms and conditions on their credit agreement says, the parties agree that the credit provider, if I can call it for lack of a better word, will not be liable for any damages that may suffer because of a late delivery. Okay, so it's specifically contracted out of the contract that the provider of the goods may not be held liable for any penalties in late delivery. The defendant owes the plaintiff R1 million, and the plea comes to say, you had to deliver on time. As a result of you being late, I suffered a loss and I'm setting it off. He files a counterclaim to do so. Will that be a triable issue? Will that defense fly in a summary judgment? Any takers? No takers. It won't, because the contract specifically contracts out of that. So how can that be a defense in law? It's you've entered the contract. Those are the terms that you agreed to, and now you want to, unless there's other circumstances, like we've amended that clause by agreement, it was reduced to writing, etc., etc. The scenario can be endless, but that's the type of thing when it's not a sustainable defense in law. Okay, so in Venter versus Kruger, the plaintiff annexed a letter to its summons to establish that the defendant had no defense. And the court said the letter amounted to evidence and was not allowed. Okay, that's to establish and to show you how you are, as a plaintiff, are prevented from saying anything in your affidavit other than what the rule allows you to. So in terms of the old rules, and if I say old rules, I'm talking about Alzaan-Jonker article days, there were rules that said, I don't have to have a defense. Or the law was at the time, you can only file a counterclaim. If I file a counterclaim, that's a defense to your claim, past summary judgment. Those rules were amended, I think, in 2011 or odd years ago to say that if you raise a bona fide counterclaim, that will not be enough to refuse summary judgment. You have to also have a bona fide defense to the claim. All right. So the court is not called upon at that stage to evaluate the evidence and whether or not they will be successful at that the defense is low. The question is, assuming the fact stated by the defendant is correct, is the defense good in law? That's the crux, right? So in terms of section 169(1) of the NCA, there's a procedure available to a consumer that's being sued for debt in terms of a credit agreement. If the consumer claims that the cost of the credit claimed by the credit provider exceeds the maximum permitted rate, and requests that the credit provider be called as a witness to prove the amount owing. This is available to a credit consumer in terms of the NCA. So what's the defendant's response to an application for summary judgment? He can either file security, in other words, pay the money into court, or you pay it into the attorney's trust account and the attorney files security, or you can file an opposing affidavit. When must you file that opposing affidavit? You must file it the day, 12 on the day preceding the court day. Okay. You have to disclose a bona fide defense, disclosing fully the nature and the grounds and the material facts that you are relying upon. A counterclaim is not enough. Case law principles that have been distilled over the years is there's facts and particulars which, if proven at trial, constitutes an answer to the plaintiff's claim. The defense or the counterclaim must be valid in law. It has to be in the defendant's favor on a preponderance of probabilities. It must not be bold, vague, and sketchy. You have to stipulate the nature and the grounds, and pure technical defenses will not be permitted. So that is a summary. So on who is the onus of proof? Estienne, I have to see if you're all alive on the other side of Teams. Estienne, on who is the onus in a summary judgment application? Ben Louis?
Yes, the onus on the summary judgment application, I would say, is on the plaintiff.
Correct. Well done. Where's your Tommy Estienne? He's not answering his thing.
I'll give him a call now, man.
You maybe just say the lecturer is very annoyed. Okay, on what is the standard of proof? It would be on a preponderance.
Alzan,
Yeah.
I'm here.
Oh, are you? Good to
Sorry,
hear.
I was listening on my phone as well. I don't know why my microphone doesn't work, but I'm here.
Okay, good to know. Good to know. Checking on you.
Good.
Okay, so the standard of proof was the preponderance of probabilities. There must be a fairly triable and arguable issue. It is an extraordinary remedy, but it also isn't. Okay, and there the rule changed 22 May, but the rule changed again now recently in lockdown, I think, where you can only apply for it after the plea. Okay. So the only evidence to be considered by the court on affidavit, the defendant may, with leave of the court, supplement his affidavit by oral evidence. The plaintiff may not reply to that supplementation. The plaintiff can give no further evidence. There's no cross-examination, but the court may pose questions. In terms of Rule 14.8, the court may grant leave to defend conditionally or subject to other terms. So what is very important there is when a defendant admits you claim 100,000 Rand, he says, you know, I know I owe him 8,000, but I don't owe him 100. You can ask the court for summary judgment for the 8,000 that he admits. So that's very important. You can get the defendant will be granted leave conditionally or for a certain amount. But where a debtor or a defendant acknowledges his indebtedness for a portion, take it. It's better than, I mean, the pressure that you have then on the defendant is far greater than if you don't get anything, where he's made an admission like that. So one has to be very mindful of what is in the affidavit answering the summary judgment. So let's assume it was always that you've got to file a declaration after 15 days. This is now in the case of a simple summons. You must remember, a declaration follows a simple summons, not when you have a particulars of claim on a combined, then a declaration is not necessary. So I just want to say that in terms of the new Rule 14, it says the court may, leave to defend may be given unconditionally. The court may, at the hearing of an application for some, make such order as to cost as it deems fit. And then obviously after summary judgment, you can also, remember, we'll get there as to what is the further pleadings that you can file. But obviously, insofar as you have the right to file a further pleading, you will have that right after the summary judgment. So let's just quickly, I just want to alert you to, the material amendments to Rule 32, the High Court 32, was 1 July 2019. In Raumix Aggregates versus Richtersand, the full court held and ordered that the amended Rule 32 does not apply retrospectively to pending summary judgments that was initiated before 1 July 2019. This is for the High Court, okay? In its amended form, the plaintiff may only apply for summary judgment after the defendant served a plea. In order to avoid, the defendant may give security or file an affidavit. And this is quite important to just see why they changed this rule. There was an investigation by the Superior Court's task team that says that deserving plaintiffs were frequently unable to obtain expeditious relief because of an inability to expose bogus defenses, because they're not allowed to file further affidavits in a summary judgment. So the courts, it's actually quite easy to get past summary judgment. Opportunistic plaintiffs were able to use the procedure to get the defendant to commit to a version on oath and then get a tactical advantage. And the burden of proof was arguably shifted to the defendant, which led to all sorts of constitutional challenges, right? So it's quite interesting to see what the rationale was. Rule 14 is not a model of clarity. It will increase the workload of magistrates as well as the cost of parties. It's unsatisfactory. Also, the fact that under the new procedure, the merits of the defendant's pleaded defense would be subjected to judicial scrutiny in what in effect is an opposed motion and not a trial. Only time will tell whether the amended rule is constitutional and does in fact promote access to justice. Okay, so there is a case, I'll see if Estienne can find it for me, where I think it was Judge Binsward recently went through what must happen in the High Court on summary judgments and how does it practically work? Does it get postponed to the semi-urgent? Because now you have to remember, a summary judgment was launched after notice of intention to defend and just enrolled in normal motion court. Now you bring a summary judgment, the guy files an appeal. Where does that go to? You want to exchange heads, etc. Now you're burdening the proof with semi-urgent role, and now the matter is actually delayed after the guy has filed the plea. So it's a work in progress, I suppose. One will have to watch the case law. So let's just deal with a plaintiff's right to apply for security, or at least a defendant's right to apply for security for costs. So this is a notice demanding security. It provides its own remedy for failure to furnish security. And Rule 60A is not applicable. It's got its own compel subsection. Now that's very interesting. It's the only rule that has that. On notice, in terms of Rule 55(1), supported by an affidavit, and defendant may have credible testimony that the plaintiff cannot pay costs. He has his financials that is available to it. It shows he's running at a loss, or he has a reasonable apprehension that the defendant won't, or the plaintiff will not be able to pay an adverse cost order. So the rules doesn't deal with the grounds upon which you can ask for costs. All right. It is only deals with the procedure. So what do you have to look at? You've got to look at the common law and other statutory provisions. And one of them is in the case of Peregrini Exploitatie Beleggingsmaatskappy and Siemens versus Data Genetics. And in that case, in the Peregrini case, it was the plaintiff was a Peregrini. And it held that the fact that the applicant for security for costs would have to proceed abroad in the event that it obtained a cost order against the respondent would have been an inconvenience and an uncertainty as to whether or not he'll realize his costs. So there, the court held that it was a Peregrini. You know, all know what a Peregrini is, hopefully. It says, then you can ask for costs because the plaintiff is from not from South Africa. How would you, as a South African, get your money from the plaintiff? So in that scenario, you'll be entitled to security for your costs. Who determines the amount? It's the registrar that determines the form, how it must be given, the security, what the amount is, and the manner. And that registrar's decision is final. Now, exceptions. Exceptions is is a legal objection to a pleading. All right? It is, you can accept to a summons or to a plea. It disposes of a matter, but who can tell me what is so bad about an exception? If someone takes an exception to your particulars of claim, what does it tell you? Any taker?
I think sometimes an exception could tell you that you're in the wrong court and you can dismiss the case in itself, or that you don't have standing or something like that, and that is very dangerous if you are the plaintiff in that regard.
Yeah, Chelsea, those examples, quite rightly, those are terrible examples. Because if it happens, it's embarrassing. But that's more a special plea, where you raise a special plea of jurisdiction, etc. An exception is an objection to your opponent's pleading. So it complains of an inherent defect. All right. So what it actually tells. Sorry.
It can be vague and embarrassing to you.
Yes. Yes.
If you did not stipulate clear enough your facts.
Correct. Correct. So an exception can save you embarrassment. And in scenarios where you can take an exception against the summons where it doesn't give a disclose of action, a cause of action. It makes no sense. It is also then vague and embarrassing. The similar requirements for when you bring an exception to a plea, where the plea doesn't disclose a defense to the plaintiff's claim, or it's vague and embarrassing. And we'll deal with that, what that means in a second. If an exception is upheld, then the pleading is set aside And the party is then again afforded an opportunity to amend its pleading. So you bring an exception by filing an exception formally, you set it down, but if you accept on the basis that the plea is vague and embarrassing, you have to allow your opponent an opportunity to remove the cause of complaint within 15 days. If the person doesn't react or tells you you can set down your exception, then you do so. All right. You can decide an exception separately. And when do you do that? When do you bring an exception based on the fact that a pleading is vague and embarrassing? A pleading is vague if it is capable of more than one meaning, or if the meaning cannot be reasonably ascertained. When it is so vague that the party does not know what the person's case is. When the averments are contradictory and not pleaded in the alternative. So let's get an example. Can anyone think of an example before I lash out the answer?
Mrs. Jonker?
Yes.
May one proceed with an exception where annexures weren't included in a particulars of claim when they should have been?
Yes, you could. Because it's vague and embarrassing, you're pleading these terms and referring to an annexure that's not attached. Yes.
Maybe with a plea, if the defendant is not actually addressing any of the defenses that were raised in the summons and is bringing in new facts and not actually sticking to what was in the particulars of claim in the summons.
That's close, yes. So who can tell me whether or not they remember the case Lillycrap versus Wassenaar? Do you remember that case? You're supposed to all go, yeah! So Lillycrap, you'll recall, said you cannot claim in both contract or in delict. You have to make an election. Do you guys remember that? So when a plaintiff sues on a contract but claims for delictual damages, that would be vague and embarrassing. Because you don't know, well, what do you meet? Do you meet the contractual provisions and the obligations, or a delictual claim? Right? So in McKelvey versus Cohen, it said that a first principle in dealing with matters of exception, that if evidence can be led which can disclose a cause of action, it's not excipiable. A pleading is only excipiable on the basis that no possible evidence led on the pleadings can disclose a cause of action. So the procedure to accept is when a period allowed for the filing of a subsequent pleading. Why? Because an exception is a pleading. And except for the vague and embarrassing ground, then you have to file a notice to remove. What must be set out in your notice? Particulars. And you've got to clearly state the grounds on which your exception is founded. Okay. So, if you look at self-assessment questions, I know not all of you have these notes, so I'm going to, I would love to take a, because there are a lot of people without, I'm going to take a photograph of this question. Maybe you can, sorry, that's just to help those that don't have the notes. But those that do have the notes, if you turn to page 62 of your notes, is there anyone out there that has notes? Estiaan, het jy notes?
Some
Ek
of
het ek het ander notes.
Well, okay.
Yeah.
Some of us
Anyone
have downloaded
else?
the notes from the online platform that we were provided with.
So that's how you, okay, understand. Okay, no problem. I'm just emailing it to myself quickly. And I'll share the screen. All right, so let's just end that one quick. There we go. Can everyone see it?
Yes, we can.
Okay, so
Yes.
I want you to quickly go through question 8, and then we're going to just loosely discuss what the exception is that we'll bring. So can you just read through it, and then I'll ask someone to see if they have the answer.
Ma'am, it's a bit blurry.
It's very blurry.
Is it very blurry? Oh.
Yes.
Yes.
Okay, so it says, I'll read it to you then. Let's just
Okay, that's better. That's better. No.
Okay, blurry again.
okay, oh sorry guys, I can't, let me see what you see. Is it better?
Yes.
Better now, yes.
Yes.
And now?
It's good, ma'am.
Okay, great. So I'm just gonna, okay. So let's just, you receive the following plea. The particulars of claim says the plaintiff is the holder in due course of a check dated 1 March of last year for the sum of 10,000 Rand drawn by the defendant in favor of cash upon the Seapoint branch of Nedbank. Now, okay, you guys won't know how a check looks like. You should actually Google it. Plaintiff is duly represented the check for payment on 2 March, and the check was dishonored by non-payment, the defendant having countermanded payment thereof. Notice of dishonor is dispensed with in terms of section 48(2)(c) of the Bills of Exchange Act, in that defendant has countermanded payment of the check. Notwithstanding due demand, the defendant has failed to pay the plaintiff the aforesaid sum of 10,000. Wherefore, plaintiff claims payment of the sum of 10,000 and interest a tempora mori to date of payment and cost of suit. So the plea is, it admits that plaintiff is the holder of a check. In paragraph 2, the plaintiff represented the check for payment and the check was dishonored because the defendant countermanded payment. So the defendant pleads. Defendant admits the contents of this paragraph, but avers that he entered into an agreement with ABC in terms of whereof ABC sold and delivered goods to the value of 10,000 Rand to him. On delivery of the goods, defendant paid for the goods with the said check. On inspection of the goods, defendant found all the goods to be damaged, returned same to ABC, and countermanded payment of the check, as it was entitled to do. So who can tell me what the exception would be to that? And don't worry, I know it's very foreign, it's very difficult. So I'll give you a little bit of help because Czech law is so archaic at the moment. So this exception would be that the plea discloses no defense. Why? A check is like cash. It's like money. So what happened here was the plaintiff got that check from ABC Pty Limited. Okay? It was drawn by the defendant. But you cannot say, I paid a third party and stopped payment of that check because they didn't comply with their obligations. You cannot countermand a check in these circumstances like that. So the exception would be that the plaintiff takes exception to the plea on the basis that the plea discloses no defense, because the plaintiff admits, the defendant admits that plaintiff is the holder in due course, but raises an underlying causa of the check as a defense. The defense is bad in law. It's not sustainable. It can never succeed. And that's why the exception will be upheld here. All right. So the next example I have for you is on the following, maybe I must do it again. This is for, sorry, let me just take a picture. So Estienne got me the Binns War judgment. Estienne, maybe you can tell the group what you've read while I was busy.
So, okay, let me just open my email again so that I can see the highlighted parts. So previously, opposed summary judgments were heard in third division on the unopposed roll for the reason of it being a quick remedy and cost effective. However, now that the rules have changed and that you have to wait for the defendant to file a plea before you can move for summary judgment, it means that there's certain consequences related to this. It's more costs for more documents being drafted. The bundles at court will be thicker. There's a greater delay in time involved, etc., etc. So long story short is the judge granted an order, a draft order that was handed up to postpone the application for summary judgment, the opposed summary judgment, for hearing in the fourth division on the semi-urgent roll. And also in the last paragraph of the judgment, it reads that no longer, okay, let me just see, it would be appropriate in my judgment for summary judgment applications brought in terms of the amended Rule 32 that are opposed to be heard and determined on the semi-urgent roll in the fourth division and no longer in the third division, as was the case before the amendments were effected. So yes, from now on, it seems that opposed summary judgments will have to be placed on the semi-urgent roll and not the unopposed roll.
Okay, so you see that shows how it will delay things even further, but hopefully it gets the attention and is then actually very well ventilated at that hearing, so that you don't, if it's a case of a defense being bad or a summary judgment that needs to be granted, it will be granted, and not a scenario where magistrates will be hesitant to grant a summary judgment. So I think time will tell. We won't know until the proof is in the pudding. And I don't think I haven't had a summary judgment recently that has been postponed for such argument. But yeah, time will tell. So can you see the next one? Plaintiff and defendant are set out on the face of the summons. On 20 May last year at Cape Town, the parties entered into a written agreement of lease, in terms whereof plaintiff let to defendant a property situated at 50 Ruland Street, Cape Town, at a monthly rental of 5,000. A copy of the lease is attached. On 1 June, the defendant took occupation and has been in occupation since then. Despite demand, defendant has failed to pay rental for the months of November and December. Wherefore plaintiff claims for payment of the sum of 10,000, ejectment, interest, cost of suit. You may assume the lease has been attached and the parties have been properly described. Okay, just take a second and think of your answer. Okay, so who can venture what this exception is about? What's wrong with that particulars of claim?
Is it the fact that a copy of the lease agreement is attached?
No.
Okay.
Kurt Gouwsventer. Are you on the air? Megan Turley.
Hello.
Hi, do you know what the exception is there?
Is it maybe the ejectment?
The eject.
That the plaintiff claims ejectment, but the lease has not been cancelled.
Excellent. That is 100% the correct answer. So your exception will be, well done. In terms of, sorry, where is it now? The exception would be, the defendant takes exception to the plaintiff's claim for ejectment on the basis that he does not disclose a cause of action. In that plaintiff alleges he's occupying the lease premises, but makes no allegation that such agreement has been terminated. And you can only get ejectment when you've terminated your lease. So well done, Megan. Okay. So that's the two examples of it. I hope you all understand exceptions better. So when an exception is vague and embarrassing, you have to give a notice. And it's just for interesting sake in the High Court or in the Magistrate Court, when you've got a pleading that has been signed by counsel, there's a practice at the bar that if you intend to take an exception based on the fact that it's vague and embarrassing, you have to phone your colleague and tell him, I'm going to take an exception based on the fact that it's vague and embarrassing. You've got that collegial obligation. Attorneys don't do that. It's quite sad, but yeah, we don't. We just do a notice of exception based on the fact that it's vague and embarrassing, and we ask for a removal of this deficiency. So after we've now gone through that, and we remember I said a simple summons is a summons that has no particulars of claim. In that instance, you have to file a declaration. Everyone always forgets to file the declaration. That's me included. You have to file a declaration in terms of Rule 15 within 20 days after a notice of intention to defend has been filed, and you can bar someone from defending from not filing a declaration. So the defendant can bar you from filing the declaration. It's quite strange. So the next pleading that can be filed is a special plea. So a special plea, who can tell me what examples, on what basis can you bring a special plea? What is the grounds for a special plea? Michaela?
Would you not be able to bring it on the grounds of jurisdiction and locus standi?
Correct. That's two of them, yes. The others?
Is a special plea not where you ask information for you to plea after your notice of intention to defend?
No. A special plea is a procedural complaint. It's based on merits, but procedural of nature. It delays the matter. It's a dilatory plea.
Prescription?
Yes. It's also based on the combined summons where you refer to the averments, especially with merits and quantums, but mostly merits.
No, it's more a situation where, for example, we had someone say jurisdiction, where the court doesn't have jurisdiction to hear the matter.
I do a lot of summons, special summons. Like I've been doing it. I've only been specializing in RAF matters with regards to special pleas. So it's basically when I've been drafting it, it was on the merits and the quantums and also the vermins of the particulars of claim.
No, you can only bring a special plea in these following instances. You can bring it when it's a lis alibi pendens case where it's already been, it's in another court hanging. There's another similar case and you are precluded from bringing this cause of action here. Or it's already been decided by the courts, re judicata, or the court has no jurisdiction, or the plea is prescribed, the claim is prescribed. That is the only 4 instances on which you can file a special plea. With a special plea, you file a plea.
Sorry, can I ask a question? Would locus standi not be a criteria?
Excuse me?
Locus standi not be an instance where you could claim special plea, lack of locus standi?
Locus standi is not, it's more, locus standi goes, can filter into jurisdiction, but locus standi is not not brought by means of a special plea. That is when someone won't be able to prove locus standi, and you bring that just by denying it in your plea. You can't bring locus standi by way of a special plea. It is a dilatory plea, and it's you can categorize it in the way of delaying an action, or that it can extinguish the action. All right. So let me give you another example. It's a numerous clauses of grounds on which you can bring a special plea. Locus standi is not one of them. Okay. So, but locus standi is a defense which you will raise in your plea. In Rule 17, you deal with pleas 20 days after notice of intention to offend or the delivery of a declaration. If it's not forthcoming, the party can bar you. If you don't file a plea, you're ipso facto barred. If you're barred, you have to apply to the court to uplift the bar. You can't just file your plea. You're barred from doing so, and the court will have no regard to your plea. In your plea, you have to admit, deny, confess, and avoid. All right? The allegations of the particulars of claim. So after you file your plea, you have the option of making an offer to settle. Can I just ask everyone who, when do you guys want to break for lunch? Oh, sorry. I forgot about my slides. There we go. So that's what we dealt with. There we go. Just in case you missed it. Okay, so after you file a plea, you can ask, you can offer to settle in terms of Rule 18. You can unconditionally do so or without prejudice. The other part, you'll do it by way of a notice. You don't file it at court, obviously, because you don't want the magistrate to see it. The defendant or the plaintiff can accept it within 15 days. And thereafter, if it's accepted, you have 10 days to perform in terms of that offer. If you don't, after you've accepted it, you've got 5 days notice to ask for judgment in terms of the offer or the tender. There's no disclosure to the court, and the pros and cons are the plaintiff will not know how the amount is calculated, and he is at a disadvantage when he prepares for the trial. If the plaintiff does not accept and cannot prove that he is entitled to that amount, he will only be awarded that amount. Costs can also be included in the offer, and for example, if you have a situation where you claim for injuries due to an attack of a dog, you're convinced that the plaintiff who is claiming 5,000 Rand will not get more than 1,000. How will your Rule 18 notice read? You will say, be pleased to take notice that defendant hereby pays into court the amount of 1,000 Rand without prejudice and as a settlement offer in terms of Rule 18.2. Take further notice that the defendant offers to pay the plaintiff's party and party costs as agreed or taxed to date hereof. So that notice, you serve the notice, and the other side just serve it, and the other side will then have to consider it, and if they don't, you can always, upon judgment, disclose this to the court. So that is how you make a tender into court. So after that, you can file a claim in reconvention in terms of Rule 20. When you have the same parties and the defendant has a claim against the plaintiff, two actions are then heard together, and you file your claim in reconvention when you file your plea. It's also called a counterclaim. The procedural differences between a summons and a counterclaim. So there are certain, a summons and a counterclaim is actually the same thing, but there's some procedural differences. One of them is you don't have to file a notice of intention to defend to a counterclaim. You can't request security. You cannot apply for summary judgment. And there are possible cost disadvantages to a successful defendant. So when you file a claim in reconvention, you usually say that you refer to the parties as they are in convention, because it's very confusing when you as the plaintiff, your particular claim mentions the plaintiff and the defendant the whole time, and then you come in your claim in reconvention where you as the defendant now become the plaintiff. And to refer to yourself as the plaintiff when you are in the main action, the defendant, becomes very confusing. So you'll start your intro to say that the defendant is the plaintiff in reconvention and the plaintiff is the defendant in convention. So it's just the parties referred to as in convention, so that everyone knows whatever document they read, it's the same person. All right. So after you file a claim in reconvention, the plaintiff will file a plea in reconvention. So he files his plea to the defendant's summons, so to speak. And after a plea has been filed to the particulars of claim, the plaintiff is at liberty to file a replication. So this is governed by Rule 21. And you do so 15 days after the plea or the counterclaim. Who can tell me when is it necessary to file a replication? Can someone venture a guess? Anyone? Does anyone recall the words, it's not a sword, it's not a shield. No, it's not a sword, it's a shield. Estienne?
I don't have the answer to this.
Ben Louis?
I recall the words, but I don't know when it's necessary.
It was part of estoppel
Ja, so,
dat ek,
dankie, Estiaan.
Benas.
Estiaan should 5 minute nog verder bly. But yes, Ben Louis, it's part of estoppel.
thank you.
So can you go even further and tell me what is estoppel?
Estoppel is when there is a misrepresentation made. Normally, when someone is representing a company, so when someone pleaded on your summons, you could say in replication, estoppel, but that has changed now after the Vodacom and McCarthy case, if I have it correctly.
Okay, nou is jy net te slim. So, estoppel is exactly what he mentioned. It's for a scenario when I sue and the defendant pleads, but you didn't have the authority to sell that to me, and the plaintiff comes back and says, well, due to the representation you made, you are stopped from relying on the true state of affairs. So an estoppel plea is always raised by way of a replication. You can't raise it in your particulars of claim because it anticipates a certain defense. All right. There is even a possibility for a further pleading to be filed after a replication, and that is a duplication. So, or as they call it more formally, you call it a joinder and a surrejoinder. So it has once happened to me that we've filed it's the particulars of claim, the plea, the replication, the rejoinder, and the surrejoinder. So it's actually quite amazing to have encountered that in your lifetime. It's very rare that that happens. Okay, so after all the pleadings have exchanged, and let's all learn out of what the pleadings are that we dealt with. We dealt with the summons and the particulars of claim, the plea, and the exception, then the plea, then summary judgment if possible, and the replication, the plea in reconvention, the surrejoinder and rejoinder and surrejoinder. So that would all be part of your indexed pleadings bundle if you when you index and paginate the High Court case. All right, or a marriage court case. So then we have litis contestatia. Who can tell me what is litis contestatia?
The close of pleadings.
Perfect, thank you. Yes, it is. So pleadings have now closed, and the matter will now be ventured off to a trial. So in terms of Rule 21A, when you fail to file a pleading, you are automatically barred. Closure of pleading when either party has decided to join issue without adding new matter and without filing a further pleading. The last day for filing a replication or subsequent pleading has lapsed and nothing has been filed, or the parties have agreed to it and filed it with the clerk or the registrar. If the parties cannot agree, the court on application can declare the pleadings closed. That is so rare that that happens because you've just got to wait for the time to lapse after filing a further pleading. Okay, so at this point, you now have sight of all your pleadings, and if you need to amend a pleading, you have to do so by way of Rule 55A. That you will deal with by way of applications when that lecturer deals with applications. But what is important to remember here is before a judgment, you can apply for an amendment viva voce in a court. So you can do it from the bar, but it's only when there's it's a misnomer, it's a clear error, typo, and that you do in terms of Section 111 of the Act. So I just want to read. So it's a very small formalistic amendment. It is not a big thing. You can't bring a substantive amendment with Section 111. Right. So after the close of pleadings, the next option available to you is a request for trial particulars. So it can only be done after close of pleadings, and you can't do it with less than 10 days notice. So in Rusland Mining and Alexcor, the SCA held that trial particulars is not a pleading. And let me explain to you what is the type of information you'll elicit from a request for trial particulars. It is, for example, to narrow your issues. So you as the plaintiff is Absa Bank, and the defendant denies your locus, and you aver that you're a registered credit provider in terms of the National Credit Act. The defendant denies your locus standi. So this is for the student that raised locus standi. In that circumstance, I will then, in a request for trial particulars, you'll discover the NCR, the credit regulator registration number, and then you will invite, in a request for trial particulars, you'll attach the registration of the NCR, and you will then ask the defendant, does the defendant persist in its denial of the plaintiff's locus standi, and specifically with its registration as a credit provider. So instead of calling someone like the big kahuna at Absa Bank to come and testify about the registration of Absa Bank with a national credit regulator, you can dispose of that item by dealing with it in trial particulars. Now remember, they can notionally come and say, no, I'm not withdrawing or abandoning that, and I'm persisting, which you can then eventually use with costs against them, because it's ludicrous to, if they are not satisfied with legit documentation, to persist with something like that. So it's just a way to dispose of irrelevant matter. And sometimes it's not irrelevant matter, because sometimes you can't prove what you've alleged, and then you're in trouble. So it's a nice tool to get all the riffraff sorted out and to get your trial ready. So now you prepare for trial. You do it by way of a set down in terms of Rule 22, at least 20 days before the date. If the plaintiff doesn't set it down, the defendant may. You diarize your file, and you use as a good idea to have a checklist to see what needs to be done, what is outstanding, etc. So the most important thing that a candidate attorney is asked to do in his stint of articles is to file and draft a discovery affidavit. I presume everyone has had an opportunity to do a discovery affidavit in a civil practice. It is an extremely important rule, and the purpose of it is to get the documents, to ask the other side to produce the documents, and to let you have copies or inspect the documents that they have in their possession. You do so by filing a Rule 23.1, 3 or 4. Now 23.1 is please discover, 23.3 tells you please let me inspect it, and 23.4 is allow me to have copies if I can. So you have to list, if you are asked to discover, you respond to that by filing a discovery affidavit. Now, you guys, as I said, with regards to the front page of a summons, it's not usually a thing that an attorney does, or a candidate attorney. It's usually the secretary, and they have the standard discovery affidavit. But do yourself a favor, next time you draft a discovery, don't just do the items and list the items and ask the secretary to type it. Go read the physical discovery affidavit. Go read what you're telling the court on the other side, what your client is actually signing. So you have to list the documents you have in your possession with sufficient detail. If, for example, you have to discover bank statements, how will you, if you have bank statements from January to December, of the same year. How would you go about describing those documents in your discovery affidavit? Any takers? There's no one I can pick on. Unless it's Ben Louis.
Hello? Can you kindly repeat the question? Sorry.
So if you have to discover bank statements from
Yes.
January 2020 to September 2020, how will you describe those bank statements in a discovery affidavit?
Wouldn't it just be bank statements attached from January 2020 till December 2020?
Yes, so you will, that it sounds very mundane, but what if you have 1 month missing?
I would probably, you would either say except for these 2 months, or you would say from this month to the, for example, if July is left out, you would say January to June and then August to December.
Perfect. That's the perfect answer. So you'll go ABSA bank statements for the month of January to June, and then ABSA bank statements for the month September to October. Correct. Yeah. So you can't just say bank statements for 2020. You have to be specific. All right, great. So what do you discover? You discover those to which your client and you may make reference at the trial. You'll discover documents which may be harmful to your case. You must discover documents that advance that of your adversary. You can't withhold documents that you know is vital to the case, even if it's damaging to you. In terms of Rule 23.3, you can ask your opponent if you think there's any more documents in the possession of the other party. You file a Rule 23.3 notice in terms of which you specifically ask for those documents. You don't say, kindly take notice that the plaintiff believes there are additional documents to those discovered. You have to then go further and say, specifically, item A, item B, item C. The response to such a notice must be by way of an affidavit. If you don't discover a document, you can't use that document, but your opponent may. In terms of Rule 23.13a, if a document is referred to in an affidavit or a pleading, you can request that specific document that has been referred to. And in terms of Rule 23.15, you may, if you think there is any document for the purposes of pleading, you may ask the other side to make document or a clearly specified document or tape available for inspection within 15 days so that you can plead. So 23.15, you'll see I've bolded, placed it in bold. That's for when you haven't pleaded yet. All the other provisions is it's already close of pleadings. You're now on the discovery stage. So there's a big difference. When someone in their particulars of claim refers to a document or a tape or whatever the case may be in their particulars of claim, you can ask for that document in terms of Rule 23.15, even though pleadings have not closed. So in terms of Rule 24, that deals with medical examinations, inspection of things, expert evidence, and the use of a diagram, plan, model, or photograph. So in terms of medical examinations, a party can require the other party to be subjected to an examination. You have to, in your notice, state what the nature of the examination is, who will do it, where will it happen, when and what time. The individual's own, who you require to be subjected to the examination's own doctor may be present. And if there is an objection to the notice, they must state the nature and the grounds thereof within 10 days. This all is dealt with in Rule 24.18. You can also ask in terms of Rule 24 for an inspection of things. You've got to specifically list what they are. It can be the state or the condition of a property. whether it's movable or movable. It can be relevant with regards to the decision of any matter in the action. Okay, and you have to give a 15 days notice of it. You, in terms of Rule 24, also file your expert witness notices. No party can call an expert witness unless he delivers 2 notices. One is that you wish to call an expert within no less than 15 days before the hearing, and not less than 10 days before the hearing. You must give a list of, or a summary of that expert's opinion. So we'll get to those 2 issues. You also use Rule 24 if you want to tender into evidence a plan, a diagram, a model, or a photograph. For instance, in a crash bash, when you have a motor vehicle accident, if you want to use a photograph of the scene, of the robot, to show the court, this robot has arrows going to the left, it has a double carriageway, etc. You have to give notice in terms of Rule 2410 of your intention to use those items. So in Rule 29A, that is when you say, in 15 days before the trial, I intend to call Piet Pompies as an actuary as a witness in the matter. In terms of Rule 24.9b, within 10 days, you have to give a summary of that expert's opinion. Rule 24.10 is a notice to say I'm going to use photos, and usually you attach the photos or the plan or the diagram. The other side has the right of inspection to those photos or plans, etc. Then you have a further option, and that is to subpoena, interrogate, or in circumstances of a commission de bene esse. So any party desiring the attendance of a person at a trial is at liberty to issue a subpoena for that purpose. Each subpoena cannot have more than 4 persons' names in it. It's affected by the sheriff, and it must correspond to Form 24 of the rules. To ensure that all witnesses attend a trial, it must be timeously served on witnesses, and you have to refer to Section 51 of the Act. Right, that's very important, and you have to tender the witnesses' costs. Okay, so the difference between a subpoena, dicus tecum, and a subpoena is the latter is, or the dicus tecum is where you want certain documents to be presented to the court. That's usually a bank official, where you ask for the defendant's bank statements or etc. So a lot of you do pre-trials. Now, a pre-trial is similar to the High Court's Rule 37 procedure. It has to do with case flow management, and it's so that you can get matters on the court, on the trial roll that is ready to go to the trial roll. So it's the court issues pre-trial notices, or any party that requests it in writing. When do you do that? When you want a simplification of issues, you want to see if anyone wants to amend their pleadings, you want to ask or draw admissions from the other side, you want to see how many experts every party is going to file, or such other matters that may aid in the disposal of the action. So it's very mindful to know that in that case, Brownlee versus Brownlee, the court ordered personal cost orders against the attorneys because they were expected to mediate a divorce. So pre-trials are not just for lip service. I know a lot of people use them for lip service, but it is actually quite useful to just simplify everything and to rather spend energy on the real issues at hand rather than discovery that's still outstanding, etc. Okay, guys, do you want to, let me just see how far I'm still going to be. I don't have a lot of where to go. So do you want to push through or do you want to take a break? Not that you're not eating behind your computer screens. Anyone? Do you want a break?
Yeah, can we really
Yes.
take a break, please?
Maybe take a short break
Resume
and
at
then
1 o'clock.
Yes, please. A break.
Okay, so what about 1 o'clock or 1:15?
1:15.
1:15.
quarter past.
Okay, I hear you. Now everyone is talking. When I ask questions, no one want to talk. Okay, we adjourn till 1:15, okay?
Okay.
Thank
Cool.
you.
See you. Okay, bye.
Goodbye.
Are we all back?
Yes.
I do believe
Fantastic.
we
Thank
are.
you for answering. All right. Can you all see my screen share?
Yes. Pre-trials.
Yes. Thanks, perfect. Great. So let's continue. I actually thought we should have gone through everything, but anyway, let's go. So, as I explained, a pre-trial is necessary for simplifying issues, and you will all be aware of that application for a date. It's in the form of a pre-trial that the magistrates now require us to complete. All right. So practically, after pleadings have closed and you've done your pre-trial, what do? You prepare your court file. Who does that? The candidate attorney. And all documents are on one side. If larger than an A4, you fold it to get into the size of an A4. If it's smaller, you paste it on an A4. If you have a stated case or an affidavit or an appeal, you have to do it in paragraphs, consecutively numbered. This is just for nice information. You've got to collate, suitably secure at least 10 days before your trial. You have to be very mindful of the regional court directives, which places certain onerous obligations on litigants in the form of joint expert notices, etc. So you've got to familiarize yourself with that, because they are very strict when it comes to complying with those type of notices. So then you have the hearing of the matter. You wear your robe. You have to dress appropriately. Your client as well. You don't rock up in a jean like people do these days. You stand when you address the court. When your opponent addresses the court, you sit. Unless you object, you don't leave the court before you're excused. You ask permission to be excused. You have to make proper use of the mechanical apparatus so that you can prepare your matter for the event of an appeal. And you've got to speak audibly and clearly. So during a trial, the magistrate speaks first and goes on record, and the plaintiff's attorney introduces himself. The defendant's legal representative introduces himself, and the parties may address the court with an opening address. The party with the duty to begin will call his first witness, then the other side will cross-examine that witness, and the court will ask questions to clarify. What happens when the plaintiff closes its case? What can happen? What's the options? And if anyone has watched the criminal trial of Shreen Devani before the now retired Judge Traversa, they can answer this question. What happens after a plaintiff? What's the possibilities after a plaintiff's case is closed? Estienne?
The magistrate or the judge may decide that the plaintiff does not have a case and may conclude the trial right there. Or
so you are referring to the words applicant or the defendant can apply for absolution of the instance.
Yes.
Or in the criminal world, a section 174 discharge. Same thing.
Yes.
Right. So that means the plaintiff has not proven what they should, the elements of their cause of action, and should lose.
Does not have a prima facie case.
Yeah, well, you haven't proven your case. So if it's not granted, the defendant presents its case by calling his witness. The plaintiff may cross-examine and again re-examination. So I don't know if any one of you watched the criminal proceedings of Henry van Breda, the axe murderer in Stellenbosch. And did anyone watch that trial? So in that trial, they applied for an inspection in loco to be taken to the crime scene. And at an inspection in loco, any party can request that you go and visit the scene of an accident, of a crime, of where the cause of action, if it's necessary. So the purpose of an inspection in loco is to observe. No testimony is led at the scene, but the court records its observations and what is pointed out by legal representatives, etc. Okay? At cross-examination, your evidence in chief is the best way to get information on the record. Cross-examination is never as effective as you may think. It always appears so in The Good Wife and all the legal suits, etc. But it's actually not correct. So you have to put your client's version to a witness. You've got to use leading questions very effectively, and you must now know the answer to your question before you ask the witness. That is effective cross-examination. So during cross-examination, you try to elicit evidence favorable to your client. You test your discredit, bless you, the discredit reliability of evidence in chief. You destroy or undermine the credibility of witnesses, but you have to also put your version before a witness for comment. That is vital. If you don't do that, you may face an absolution or an objection that you can't make statements of fact because the witness, it wasn't put before the witness. So the duties of a cross-examiner was very well considered by the Constitutional Court in the Sarfu case, where the court held that if a point is left unchallenged, then you accept that to be correct. So it paints a nice picture of the expectations of a cross-examiner, etc. And it's nice to go read these cases now when you, at this stage of your careers, that now you understand what the relevance was of these cases in practice. So after all of your witness evidence has been led, you have legal argument both sides, and you must always remember the most important thing for attorneys are our costs. Otherwise we work for free, we only get the tariff, which we all know is negligible. So we can always withdraw a matter, we can ask for a dismissal, or we can settle it. So I don't know if you guys, those that have studied at Stellenbosch, will remember the words, a bad settlement is always better than a good court case. And those words you have to always remember, because to settle a case is far better for your client, for the other side, for yourself. And no one in settling a matter feels warm and fuzzy inside. They all feel that they lose, but in the end, they will be grateful, because litigation is very expensive. And I know it seems like I'm lecturing by taking money out of our mouths, but at the end of the day, that client will think you are very competent because it's in his best interest to settle. So you can use Rule 27 to draft settlement agreements and to make that an order of court. And why is it better than an acknowledgement of debt? Because after you have instituted action and you want to settle, you want your settlement to be made an order of court. So that if the other side breaches that agreement, you can immediately issue a warrant of execution. So Rule 27 deals with withdrawals, costs, and if you want to make a settlement agreement an order of court, you have two choices. You can either record the terms of that agreement, which means if there is a breach, you have to apply for judgment on the settlement agreement. If you make it an order of court, you have a judgment. You can just issue a writ. That is extremely important. To record the terms is sometimes agreed because the parties don't want a judgment against them. But the other, or it's already entered into, it doesn't go to ITC because ITC doesn't look at that entry into a court file. So it's quite effective. But in terms of Rule 27.7, you have to, the other side needs to be present when you make a settlement agreement in order of court, or they have to waive that right in the agreement. When you have to approach the court to make this an agreement, an order of court, you do it by way of a long form in terms of Rule 27.9. It's an application which is served on the other side, but 3/4 of the time you enter into a settlement agreement at trial stage, and then you just on the day of the trial you make your settlement agreement order of court. So then the long form application won't be necessary. So now we've dealt with a matter that was defended, and we have to also traverse when an action is not defended. So when an action is not defended, that means the party has not filed a notice of opposition or a notice of intention to defend. You as the plaintiff are then entitled to apply for default judgment. You do so in terms of Rule 12, and be mindful of the regional court directives that I pointed out earlier, especially with regards to a damages claim. Right? There is some procedural formalities that the regional court requires you to comply with. So the basis of a default judgment is that it's deemed an admission of the claim by the defendant. When can it be granted? Oh, there's a notice in the summons that also makes provision for the defendant to admit to that claim, to consent to judgment. So when do you apply for default judgment? When you have filed, when there's no notice of intention to defend, or you have placed the defendant under bar. Okay, Rule 12.1a and 12.1b. So Rule 12.2a deals with where the defendant has filed a defective notice of intention to defend. You've alerted him to it and he's not corrected it. Then it's deemed to have been no notice of intention to defend. All right. 12.1b deals with the failure to file a plea. He's entered an appearance to defend, but have not delivered his plea. The plaintiff then delivers a notice in terms of Rule 12.1b and demanding the defendant's plea within 5 days, failing which they're ipso facto barred. All right. You can then apply for default judgment. And in the case of Santam versus Bumber, the defendant failed to deliver its plea after filing an appearance to defend. The plaintiff delivered a notice of bar, and on the last day of the 5-day period, the defendant served its plea, but only filed the plea the following day. The plea was thus delivered 1 day late, entitling the plaintiff to approach the court for a default judgment. So default judgment was granted, and an application for rescission of the judgment failed. So, however, it was overturned on appeal, and the court said that the plaintiff's attorney could not have been in any doubt that it was the defendant's intention to defend the matter. All right. A request for default judgment is nothing else than an ex parte application where an applicant is generally required to make full disclosure of all the relevant facts. All right. The court held in Santam that the approach always had been and would continue to be that a defendant should not be easily deprived of the opportunity to defend its case. The court expressed its displeasure at the conduct of the plaintiff's attorney. Because when you get a plea on the 5th day, fine, delivery of a plea means service and filing, but if you then apply for judgment knowing they haven't filed it, that the court will not take that conduct very lightly. So there's been an amendment to Rule 12.1b, Rule 21a, which says you can bar on any other on a counterclaim. All right. So the formalities when you apply for default judgment is a request for default judgment. You have to file your summons, your original summons, your return of service, proof of your Section 129 track and trace registered slip. If you have any other evidence, you have to file it by way of Rule 12.4. So you have to And if you don't have your original attachments, for example, your original agreement of lease, you have to file an affidavit saying it's lost and you've taken all the steps to try and locate it. But after a due diligence search, you cannot find it. All right, so Rule 63 deals with, let me just get there. That's when you don't comply with the rules. And that is also a situation that is dealt with by way of a default. So when you haven't complied with rules and the other side brings an application to compel you to comply with the rules, you can apply after they've not complied with your notice for them to comply. You can apply for default judgment. So you can, on the same papers, approach the court and it's dealt with as if it's a default judgment. So service of summons by registered mail needs to be attached. What is the costs? You can only get costs on a default basis. So in the tariff, in the Magistrates Court tariff, you have a whole schedule where they deal with costs. Let me just get there for you. And it talks specifically in Annex 2, Part 2, it deals with undefended actions. So there's a specific tariff. If you've issued a summons and you've applied for default, you can only get the amounts as listed in the tariff. If you've got a defended action, you are most probably in all scenarios, you're going to ask for costs to be taxed. So that's the difference between the two. There's a set tariff for undefended matters. If you guys have regard to this question, you're instructed to issue a summons on your client's behalf for 18,000 Rand in respect of damages to his vehicle. The defendant files a notice of intention to defend. May the plaintiff apply for summary judgment? Ben Louis?
Yes.
No.
Sorry, it went off now.
Oh, sorry. Oh. Sorry. Do you have it?
No.
Still not there.
Yeah, it is now. No, you might not apply for the summary judgment.
Why?
Because you only have to wait. You have to wait for the plea of the defendant.
Oh, that's a very good answer. Okay, let's assume they filed their plea.
Yes.
May you apply for summary judgment?
Yes, you may. If
Why?
yeah, if there's no defense open in the
Okay, in this
No,
scenario,
because it's a claim for damages.
Yes, it's a claim for damages, so it's not a liquidated amount.
Okay.
And why do I say that? Because the vehicle will have some sort of value. The wreck. Okay?
Okay.
So if you just claim for 18,000, the other side will say, but the car is not a write-off. What is there will be a debate about the quantum. In this case, it's an absolute damages claim, and you won't be able to apply for summary judgment. If the notice of intention is defective, you can, after asking for them to clarify the defects, you can apply for default judgment. So if we say the reasonable market value of the vehicle was 20,000 Rand, and the plaintiff sold the wreck for 5,000, the costs of the repair is 18. What will the plaintiff be entitled to apply for judgment? Christian?
Amount I've net gekyk, sorry, did he already
sold
pay
it.
for the wreck? So he hasn't
sold
repaired the vehicle.
He sold the wreck for 5,000.
But he hasn't repaired the vehicle.
No, he sold the wreck.
So he lost 15,000 rand.
Correct. So he will be entitled to 15.
Yes.
Okay, so you will also include an affidavit in terms of Rule 12.4. Why? Because you will need for a damages claim an affidavit by an expert, which will be a panel beater in this instance. That would be your expert. All right. So when you have a judgment in your favor, you can also get a situation where your client comes to you and says they've got a judgment, I want it rescinded. Okay? How do you rescind a judgment? That's Rule 49, and they will deal with it under applications, but that's just for you to know that a default judgment can be rescinded. All right? Then, if we deal with provisional sentence proceedings, this is a very complicated part of a summons. It's dealt with Rule 14A, and it takes the form of 2A of Annexure A to the rules. It is a very unusual and extraordinary remedy because it mixes an action with an application. Okay? How does it do it? An action is commenced by way of a provisional sentence summons, but pleadings are filed in the form of an affidavit. I actually wonder if I've got an example. I actually do. I don't have it at hand. So you can only bring a provisional sentence summons. You can only issue a provisional sentence summons if it's based on a liquid document. What is a liquid document? That appeal court case defines it as a document upon which, upon a proper construction, evidences by its terms and without resort to evidence, an unconditional acknowledgement of debt in an ascertained amount of money and of which the payment is due to the creditor. So the characteristics of your document must be established without resorting to extrinsic evidence. So it's only the document. The document speaks for itself. An example of that is an acknowledgement of debt, which has an ascertained amount of money. Payment is due by the debtor to the creditor. The signature on this document must be the signature of the debtor. So in that appeal court case, it dealt with the requirement of liquidity. Liquidity cannot be retrospectively conferred by way of a certificate. It cannot make an illiquid document liquid merely because there's an agreement. Okay? So again, you don't resort to any extrinsic evidence. The onus of proof is on the plaintiff, and he has to show the document is liquid, that he is the creditor, and ex facie the document, the defendant is liable to the plaintiff. In the absence of a defense, the court grants provisional sentence. Why? The document raises presumption of indebtedness. The onus of proof is on the defendant to contest the liquidity of the document. In other words, he says it's not my signature, it is fake or fraudulently affixed thereto. Event in which payment, if a contingent has not been complied with. In other words, I will owe you $1 million if you paint my car. That will not give you ex facie the document liquidity. So, and the defendant may raise something outside the document, but that's the onus is on the defendant in that case. So you set it down in your summons with no less than 3 days notice. The defendant may appear, or a practitioner may admit, deny, confess, or avoid by way of opposing papers. So you issue a summons, which you usually do in an action, but you answer it not by way of a plea, but by way of an affidavit. Okay? There's an opposing affidavit filed, a replying affidavit filed. There is no oral evidence, as you would expect in a defendant action, unless the defendant denies the authenticity of his signature. Okay? Another example is you can apply for provisional sentence when you rely on a check, unless the guy says, that's not my signature on the check, it's fraud. Okay. If provisional sentence is refused, it may mean the end of the matter, and the court can find that the document's not liquid. Other cases, the court will order the defendant to deliver a plea. If provisional sentence is granted, what is the effect and what is the advantage of that? Provisional sentence means you can only defend the case if you pay the debt. So a plaintiff gets his claim amount immediately and then only fight about the merits of the case. The safeguard is built in that the defendant can require security for the payment of the judgment debt, so as to not have the plaintiff start off with his money pending him disputing the merits. If the defendant does not pay within 60 days after the provisional sentence is granted, he's not allowed to enter into the principal case, and the provisional sentence becomes final. So just to recap, the requirements is it's a liquid document. The onus is on the plaintiff to satisfy the court on the document's liquidity, that he or she is the creditor, and ex facie the document the defendant is liable. There's a presumption of indebtedness, which may be rebutted by the defendant on a balance of probabilities. The defendant has the onus that he can contest the liquidity, he can contest the authenticity of his signature, and he can say that there's an event on which the payment was contingent but wasn't complied with. So on that score, can anyone tell me who likes Krooner champagne? Okay, I do. So you will recall, this is a very interesting point. Krooner, the champagne, belongs to the farm Twee Jongen Gesellen. Twee Jongen Gesellen went to the Land Bank of South Africa in 2011. They ended up in the Constitutional Court, and they changed the law of provisional sentence forever. So in that case, they changed the phenomenon because it was millions. I mean, I can't even tell you how much money was owed to the Land Bank. And for them, the Land Bank then issued a provisional sentence summons, and they had to pay something like millions to just enter into the case. And the Constitutional Court held there that it is only available who is armed with a liquid document, a plaintiff, but it constitutes a limitation to a defendant's right to a fair hearing, especially where he's not allowed to show a balance of success without the benefit of oral evidence. He's not able to satisfy the judgment debt because not everyone has that money lying around. And outside special circumstances, the court has no discretion to refuse provisional sentence. So the court found that provisional sentence proceedings constitutes a limitation of your right to a fair trial. And the common law was developed so as to allow for a discretion to the court in circumstances where a defendant can show he cannot satisfy the debt, an even balance of prospects of success shows on the papers, and that there's a reasonable prospect that oral evidence may tip the balance in the defendant's favor. And on those three sets of circumstances, the court can refuse the provisional sentence. So is an provisional sentence appealable? No, because it's not a final judgment. It's an interlocutory finding. It is a judgment of such a nature that the plaintiff can get the benefit of the judgment debt but he has to file security and he still defends the main merits. So it's not a final judgment. So the last example of a lot of all the summonses is the interpleader. So the interpleader is dealt with by Section 69 of the Act. It deals when any person other than the judgment creditor goes and sends the sheriff to your property and the sheriff attaches your goods. Then someone else comes along, a third party, and says, but it's my lounge suite and my fridge and my Ducati standing in the garage. Then a judgment creditor instructs the sheriff to serve an interpleader summons. And that is when any person other than the judgment creditor makes a claim to property attached or being attached or to the proceeds of the property sold. So 2 or more persons makes adverse claims against the possession of a third party's goods. The procedure to be followed is reflected in Rule 44. You can serve you must bring it against the serve it on the person making the claim by the sheriff. And in practice, you can either, when you, as the judgment creditor, is also served with the summons, and you can either admit the third party's claim, or you can say no, the goods on the premises is subject to the landlord's hypothek, as dealt with in the case of Bloemfontein Municipality versus Jackson. I hope everyone remembers that case, where it dealt with the landlord's hypothek. And also goods in terms of Section 2 of the Security by Means of Movable Property Act are also exempted from interpleader stakes. So those 2 are examples of where a third party, unfortunately, will be unsuccessful in the interpleader because of those 2, the landlord's hypothek and the Security by Means of Movable Property Act. Does anyone have any question? No one? Tired of listening to me?
Alzan, do you know how will they ask these things in the exams? Will we have to draft it, or will they ask us what must you list in summons?
They will. You've just got to go through papers. They don't ask a lot of difficult questions on these topics, but you will just have to go through past papers. I don't know if they make it available to you.
Yes, we have it.
But
Thanks.
They're very consistent in their approaches.
Thank you.
I just wanted to find out if we can get the email address so that
yes,
we can get the slides.
Yes, sure. So what I can ask everyone to write down the following email address. It is ESTIAN@mindes, MINDES.co.za. And I repeat, ESTIAN@mindes.co.za, and he will send you the PowerPoint presentation. Okay.
Thank you.
I also invite anyone that has a question on this part of the course, you're more than welcome to give me a call. My number is 021 918 9020. I'm happy to assist, and I wish everyone luck with their exams. And that brings us to the end.
Thank you very much.
Thank you very much. Thank you for bearing it with us. And
Thank you,
good luck
Amber.
with everything. Okay. Bye,
Thank
guys.
you.
Bye.
Thank you. Bye.
Thank you.
Thank you very much. Goodbye.
Is a lecture going to follow an application procedure?
I'm not sure. I'm also waiting to hear.
I think a Mr. E. Barnard is supposed to be conducting that. Is that today? I think we need some
Perhaps we
clarity
should.
on that.
I think we should send the email to Prudence asking her.
Or should I send an email?
Hi everybody. I've just called Mrs. Jonkers now, or Mrs. Jonker, and she was able to confirm that our lesson on the application procedures for Magistrates Court will take place on another day. It's definitely not part of this web seminar at all, and it won't be conducted today. So I think it is safe to assume that we can log out then, and that we are done.
Thank you.
Thank you.
Thank you.
Sorry, I just want to confirm, can we use the same link to log in tomorrow, or will a different link be sent?
No, it's the
Prudence.
same link for the rest of the week,
Same link.
apparently.
Okay, so it's the same link.
Yes.
Okay, thank you very much.
Hello, everyone. Hello? Hello?
Hello, everyone. Can you hear me, guys? I've just been informed that the instructor has finished class, so you can log in. For tomorrow, you can use the same link again. So we're done for today. There won't be another class.
Thank you.
Thank you.